Michael Veder, welcome to the DCQ podcast Special Sits. I'm happy to have you on today. How are you?
Well, thanks, Peter. Thanks for the invitation. Very happy to be here as well. I'm fine, actually. And yourself?
Yeah, not too bad, actually.
Good.
So you're joining us from the Netherlands today. Where exactly are you?
Well, now exactly I am in my study at home in Utrecht, where I live.
Excellent. So if you had to describe the Netherlands and being Dutch to somebody who, has never visited the country and knew little about it, except for maybe, tulips, cheese, wooden clocks, windmills, bikes, and maybe Vincent van Gogh. But what would you say to them?
I would say don't forget Rembrandt van Rijn. And don't forget all the beautiful museums that we have here. Peter, that's a very difficult question to ask because the Netherlands, is, as you know, is a very diverse country. It's a very open country. So, for our line of work, very open to influences from abroad. People are, generally speaking, I should say, open-minded. It's a very pleasant country. It's beautiful. It's rather small.
It's densely populated. Yeah, I'm asking it, Michael, because obviously, like yourself, I grew up in the Netherlands, but 25 years ago, I moved to the UK, and I've been here ever since. Obviously, still in and out of the Netherlands, but I'm not living there anymore. And I wonder whether the Netherlands has significantly changed in the meantime, or whether the key characteristics are still there.
Well, I can tell you that over the last 20 years, so the one major change that occurred is the three new members of the family, so my three kids. They've significantly changed the landscape, Peter. Has it changed? Yes, I think it has changed, as you would expect it to change with the changes that you see in society globally. So from a technological perspective, I think we discussed this the other day, Peter. I still remember when I got my first mobile phone.
Yeah.
I still remember when the BlackBerry was introduced, and where only the partners at the law firm where I worked at the time actually had a BlackBerry, and all the associates desperately wanted one until they got them.
Yeah.
A lot has changed, I think, and also the political landscape. Well, let's be honest, and that's been over the last, let's say, 5 to 10 years. There's been a significant shift in the way we. Well, let me say there's a lot less solidarity, or there appears to be a lot less solidarity now than there was previously.
Yeah, because in my mind, the Netherlands, obviously a country of traders, small, densely populated, but, known for tolerance, known for democracy. And I guess, becoming...
That's a risk.
Sorry.
And I said, and that's a risk.
And that's a risk. And obviously the society, becomes a lot more diverse. I think we'll get into that, when we're talking about mentality towards, I guess, special sits. But maybe, can we maybe start your journey by the beginning and just, see, well, how and when did you decide to, pursue a career in the law, and how did you end up in the special sit space?
Well, in law, that was a choice that I made back in, what was it, 1987, 1988. So I went to law school in 1988.
And was that influenced by, your dad, the family? Is it sort of something that runs into the family, or was it just something independently that you decided, well, I'm going to do this?
It's something that I decided. I think if you look very carefully, there are a couple of lawyers in my family, but it's not as if I come from a family of, where it would be totally self-evident that I would go into law. Not at all. I wanted to pursue studies that were of societal interest, broad enough to open up various avenues, because when you're 18, you don't know, well, at least I didn't know what I wanted to do when I grew up. So I wanted to do something which interested me, which was of relevance, and which would allow me to do various things depending on where my how my interests developed. And my career towards special situations, I'm now, as you know, a law professor at Radboud University in Nijmegen in the Netherlands. My career is it's a bit of a coincidence, really. I was writing my LLM thesis in the summer of 1994, and one of my now colleagues came up to me and said, "Well, Michael, I know that you're writing an LLM thesis in private international law and specifically aimed at cross-border insolvency," which was rather novel at the time. There were only a couple of people that at that time, in the Netherlands at least, had studied that particular area of law. I always wanted to go into private practice after law school. And then I decided, well, it doesn't hurt to broaden my horizon by teaching property law, by teaching contracts, by, various areas of private law, but also to gain a more in-depth knowledge of, in this case, cross-border insolvency. That's how it all started. And then
but you started to study law, and then it took you a while to decide then to actually leave the university and go in private practice. And when you started studying law, was it immediately already a focus on insolvency, or when did that interest sort of occur?
It was one of my classes in private. Well, first of all, we were taught property law, which involves a lot of insolvency law by my later PhD supervisor, Bos Kortman, who is, I think, one of the leading figures in insolvency law in the Netherlands. And at that time, from an academic perspective, really put insolvency law on the agenda. I would say that until the early 1990s, it was more of an area that was relevant in practice, extremely relevant in practice, but from an academic perspective, there was not a lot of interest in it. And he showed us as students, me, how interesting it can be and how difficult the puzzles are that you need to solve. And I think that challenge captured me. And then I think it was one sentence in a class on private international law where my professor of private international law said, we have, when it comes to jurisdiction and applicable law, there are particularities when it comes to insolvency. And I will not go into detail now. And I thought, well, that's interesting. I can maybe combine the two. So I think that's how my interest started. And this was, let's say, in my what now would be the master's phase of my study, which didn't exist at the time.
Yeah. So, I mean, I guess in practice and maybe also in law school, insolvency was probably just a bolt onto something else, right? It arises in, in property law, if you do company law, there's a life cycle of the company, and insolvency may come up, litigation, there may be, pieces that sort of are litigation in the context of an insolvency, finance, same thing, right? But it has, over time, definitely if we're sort of looking back 30 years, developed a lot and is something that, stands on its own 2 feet at the moment. And the term special situations, wasn't there when you and I studied law and even started practice. How did that come about? What do you think was the catalyst of actually, insolvency law being, something that people started to focus on more and more and growing into, a specialization on its own?
I think the catalyst would have been its relevance to, first of all, distressed companies in particular, but to society as a whole. A proper insolvency regime that allows you to liquidate quickly and efficiently where necessary, but restructure where possible and keep businesses alive, turn them around. That's of great relevance to society. And I think, and it's always been around, but over the last, I've been in this game for about 30 years now, like yourself. It has become increasingly important in that respect, and because I think people realized how important it is as an integral part of the macroeconomic puzzle.
And do you think that has something to do with mentality? That's why I sort of, asked the first question about the Netherlands and, has it changed? And how does it sort of, affect the mentality towards, I guess, financial distress, struggle, not focused on something that, you deny and ignore. And then, at the very, very late stage, you address it, but you can't address much and it's all a liquidation. If you want to, move towards, I guess, what we call the rescue culture, which is something I believe, has developed over the last 30 years. And in my mind, the sort of, blueprint for that, or the example for that, has been, for a long time, the US. Do you think that, when you started law school and maybe practice, that the mentality towards financial distress was different, more focused on liquidation, and it has changed? And if so, how did that come about?
It's difficult to say how it came about, but it has certainly changed. And I think that has everything to do with the tools in the toolbox. When you and I started practicing 30 years ago, insolvency in the Netherlands was primarily aimed at liquidation. At least the whole process was aimed at liquidation. But at the same time, we used that process, which was, again, aimed at liquidating the debtor's assets. We used that process to save businesses by basically selling them as a going concern, but by way of an asset deal and not by way of what we now see happening very frequently, by way of a restructuring of the balance sheet.
Yeah, it was a restart, right? You use bankruptcy as a tool to actually sell the company, in a way similar to, I guess, what you have in the UK, a pre-pack administration sale.
Yeah, and that, yes, indeed. And if you talk about developments and mentality, I think the Netherlands, again, being a very open economy with practitioners, academics, students who speak their languages and who understand English and who have an interest in what happens elsewhere in the world. And you see that, I think that open mind towards what happens elsewhere has triggered certain very important developments in in our insolvency process. So first of all, you mentioned the pre-packed administration in the UK. Actually, one of my colleagues at the firm where I'm an advisor at RESOR, Nico Tollenaar, I think back about 10, 15 years ago, had looked at the pre-packed administration and called out to our insolvency judges, please give us this same tool. And practice made it happen. So from there, that practice of pre-packed sales out of insolvency, pre-arranged sales out of insolvency grew until the Court of Justice of the European Union told us that there were certain difficulties there, and the tool is much less prevalent now. The same you see happening in the restructuring sphere, where Chapter 11 has been the example, the guiding light for many jurisdictions who reformed their insolvency law, but the same happened in the Netherlands. We looked at, and this was also a number of years ago already, well, over 10 years ago, when, again, practice and academia together said, well, listen, we see these tools in the US. We see the scheme of arrangement in the UK. We need a similar tool in the Netherlands to allow a debtor with a viable business to restructure its debts without going into a proper formal insolvency process, because the formal insolvency process is value destructive. It's stigmatized. It's not good for business. So, and we started developing a tool where we picked elements from the US Chapter 11 process and the scheme of arrangement, and that has now become the Dutch scheme.
The WOA.
The WOA. And parallel to that process, the European Union stepped in, but we had already started in the Netherlands. So you see lots of developments in the Netherlands that have been influenced by what happens elsewhere. And we saw in practice that it worked. And we saw in practice that companies in distress that did not find the tools that they needed for their particular situation moved to the US, moved to the UK. Dutch companies that use the English scheme of arrangement, German companies, Spanish companies. And I think it was, and at that time we said, well, we need something to provide for such situations that happen in our economy without the necessity of companies actually seeking their solution elsewhere.
Yeah. So you mentioned the stigma attached to bankruptcy or insolvency. Would you say that that is still very much the case? That in, I guess, maybe outside of our special situations bubble, but in day-to-day life, the man and woman in the street, insolvency is very much still has a negative stigma attached to it.
It depends on the kind of insolvency. If you talk about bankruptcy, so
personal bankruptcy or
personal bankruptcy, but also business bankruptcy.
Yeah.
And in bankruptcy, assets are liquidated. That's the whole aim of the process. I think bankruptcy still carries a stigma, yes, and that's very difficult to change. I believe in the US, it's you're not frowned upon when you've gone through Chapter 11 or when your businesses have gone through Chapter 11. It's seen as, okay, you've tried, you didn't succeed, too bad, start over again.
Yeah, you've learned, and hopefully if you're not a fraudster, but it was a business risk materializing, and you've dealt with it in an appropriate way, have another go. But
Yeah.
you know, my sort of experience with the Netherlands and the UK and continental Europe, you know, as a whole, has always been that, as compared to the US, the attitude and mentality has always been different, less encouraging for, you know, people who may have stumbled, get up and go forward, you know.
Yeah.
But that has changed as well, I think. It has improved, and I think with the tools in the toolbox and, you know, learning from experiences abroad, it seems as if that has also, you know, affected in a positive way the business mentality. But I wonder whether that indeed, you know, on the ground in the Netherlands is the case, that, you know, it's something that business people will address without feeling sort of, I don't know. It's a personal thing too, right?
Peter, if I ask my neighbors, I think they will still regard insolvency or bankruptcy as a bad thing.
Yeah.
If you ask business people or people in our profession, insolvency doesn't carry that stigma anymore as it used to. And we're just trying to find a solution to the problem that a business is facing. And with the introduction of these rescue tools that we now have, they don't carry the same stigma as formal bankruptcy does.
So we were talking about, you know, the various tools in the toolbox and the change in mentality that, you know, has occurred, and the stigma, or, you know, the much less stigmatized tools that are in the toolbox now and are used in practice by business people, which, you know, I think is exactly what needs to happen for, you know, tools to actually be effective and a mentality and a culture to change. I'd like to, you know, go into a lot more detail into that, you know, during the conversation. But maybe let's go back to, you know, you in law school and sort of, you know, being introduced to insolvency as a potential area of interest. When you graduated, you didn't immediately go into private practice, but you started, you know, out in the university. What exactly was it that you did when you graduated?
I graduated late August 1994, and by the 1st of September 1994, I was lecturing. I think at that time, first-year students. So what now would be first-year bachelor students. And I was teaching them contract law, property law, tort law, and all that stuff. So I went into lecturing and research. And again, the lecturing allowed me to broaden my view of the law and my experience and knowledge of the law, because it required me to look at contract, torts, property, company, secure transactions, and the like. But at the same time, I was doing research for my PhD thesis, which gave me depth of understanding of, in my particular case, cross-border insolvency law. So more of a private international law, but also comparative law. And I already mentioned my thesis supervisor, who you know as well, Bas Kortman. At that time, he set up the academic forum for INSOL Europe. He started a project with an international working group comprised of a number of experts of a number of European jurisdictions that looked or searched for principles of European insolvency law. And I had the luck, I think you should say, to be involved in all those projects. I got to experience firsthand how much fun comparative law can be, how much we can learn from other jurisdictions, and how important it is to not just look at the law in the books, but to see and to experience and hear from experts how the law in action actually works. And that initial phase shaped my career. Until this day, I work in comparative law. You need to have an understanding of what happens in the US or in Spain or in Poland or wherever to think about how that should or could play out in a cross-border context.
So there was an academic interest first and foremost, more so than actually going into private practice. You felt that you wanted to teach.
Yes. So a complete coincidence that brought me here, and then when this happened, I truly enjoyed it, and that's true until this day. The atmosphere of working at a university is tremendous. I shared an office at my law school with Professor Jaco van Hees, who was not a professor at the time, but who was who later became a partner at the Brauw Blackstone Westbroek, the firm where you also started. And I was introduced through him and through Bas Kortman to Simon de Ranitz, former president of INSOL International, amongst many things. And I thought to myself, I still want to go into private practice. If I do, these are the two people that I want to teach me how this works. So I joined the Brauw.
Yeah, you joined probably. It's almost like you came in and I went out because I think it was in 2002, if I'm not mistaken, that this happened. Right? Yeah.
True.
No, exactly. Jaco van Hees was sort of the example of somebody who combined academics with private practice, found a balance also in the area of expertise that you're interested in. And obviously Simon de Ranitz, very important in my career as well, because he was the sort of, the partner looking after me when I started. He introduced me to to insolvency and that stuck and it's a little bit of luck, like who it is that you're sort of connected with, but for me it had a profound influence. So you thought,
same is true for me.
Yeah. Wow. And but you then, I think, started private practice full time. So you didn't combine it with academics. You sort of had done, 6-7 years of academics post graduation, and then you decided, well, actually now I'm going to do full time private practice.
Indeed. So but I still combined it with a little bit of academic work. But my focus was I was a full-time lawyer at the Brauw. But in the weekends or whenever I had time, I did still do research, wrote case notes, wrote the occasional article. I actually finished my PhD thesis in the first year and a half that I joined the Brauw, because I wasn't quite finished with my PhD when I actually moved to private practice. So I still combined the two. And the focus of my law school, where I studied and did my PhD, it was, I guess it was normal. I didn't expect it to be I didn't expect anything otherwise than to combine it. But so where the first, let's say, 6, 7, 8 years of my career were academic work with the occasional practical things that came along, the cases where my thesis supervisor was asked to advise in. I then switched it around, full-time practice with the occasional academic work.
And do you think that actually the combination is the ideal way of being an academic? Is also being with one foot in practice? Or did you think actually, you know, obviously doing it full time, especially in the area of special sits, it is quite a demanding, well, private practice is demanding as such, but this is also an area where, you know, there's urgency involved, it's unpredictable, and how do you combine, you know, an academic career with a private practice career in this area?
Your first question, is it the ideal setup? Yes, for me it works perfectly well, because now after the Brauw, I became a professor of property law at Utrecht University, and about 13 years ago I became a professor of insolvency law at Radboud University. And then when I moved back into academia, my focus was academic work, but with a practical angle. So I still combine the two. For me, it's the ideal situation. It works for me. How do you practically combine it? I don't do day-to-day cases. I think that's the short answer. I remember when I had first moved to back into academia. This must have been about 2009 or something. We were both involved in a case concerning an attachment on, I think it was a collection of rare books that
That's
was
right, yeah, movable goods that grew legs and walked from one jurisdiction to another.
indeed. That was challenging. It was very difficult to find the time to work on that case from day to day, whenever it was needed. And I don't really do those things anymore. Now my role is as a sparring partner for the lawyers at RESOR. I give legal opinions. So that's manageable, where I can think about the legal aspects of a case, the complex legal questions that arise in a particular case, instead of actually managing a case on a day-to-day basis.
Yeah. So from the Brauw, you joined, I guess, the spin out of the Brauw into RESOR. Can you say something about, you know, that? Because you were one of the, I guess, the original 5 that started that firm.
I guess again a coincidence. I met Nico Tollenaar when I was lecturing for the Global Insolvency Practice course of INSOL International. Yeah. And he wanted to start his own firm. And I knew at the time that the people that originally started RESOR wanted to set up their own shop as well. And we sort of, I can't say that I brought them into contact with each other, but this happened. Those initial contacts, I should say, Jacob van Hees, Lucas Kortman, and Nico Tollenaar, and Sander Ranitz set up RESOR. And I immediately joined them as an advisor. Because,
okay.
Yeah.
So you were the facilitator, but at that point in time, you know, you'd made up your mind that after the experience of full-time private practice with the Brauw, you now wanted to, you know, have a different role and not, you know, run day-to-day cases, but be an advisor and do it more on a part-time basis, so you can combine better your academic career with, private practice.
Indeed, that's the case. And let me be totally honest. When I made this choice, I made it at a point in my life where my wife and I just had our second child, and I really wanted and still want to be around them. And being in private practice, in the practice where that can be challenging.
Absolutely. I mean, look, it is it's a profession that has a big impact on your life. Many times a very positive impact, but it could also be challenging for other things than your profession, and family is definitely one of those. So that was a conscious decision that you made.
Yeah, I mean, it was one of the elements. One of the factors that was relevant in my choice. The most important one was that I truly enjoy teaching and research, and I really get a lot of energy, and I really enjoy supporting young academics in their studies, in their research. The drive of the young people that I now supervise myself, who write a PhD at my law school, is tremendous, and I really enjoy that. So I think that is the primary reason why I chose to shift the balance from full-time practice to essentially full-time academia, but with one foot in practice, but as an advisor.
Yeah. And what do you think? So, what is the role of academics in, I guess, the development of the law and maybe development of the, I guess, the rescue culture that we were talking about, right? It needs a number of things. It needs tools in the toolbox, so it needs legislation and tools that can do it. It needs practitioners, but it probably also needs academics to sort of assist in their way. How would you, describe the role of the academics in the development of, this changing mentality that results hopefully in a more rescue culture in the Netherlands?
I think when you talk about change in mentality, but let's start about changes in the law. When you're thinking about introducing new tools in the toolbox, which we've done a number of years ago, this is a joint, and should always be a joint effort between practice, so legal practice, but also the finance and accounting and the turnaround people, so operational turnaround. You need the judges need to be on board, and academics need to be on board to create legislation that has a solid basis, that works in practice, but also fits into the legal regime that we have. And especially when you think about introducing tools from US Chapter 11, the UK Scheme of Arrangement, academics are used to critically analyze and think about how these elements can be fitted into, in our case, the Dutch legal system. And you specifically see this also on a European level. I think academics are a crucial player in law reform in the European Union, where we have 27 different legal regimes. And academics can help to analyze and develop harmonized rules that have a basis or that can fit into all these legal systems. So they also, it's a joint effort of all people involved in our case, special situations.
So you mentioned the European dimension, and do you think that if you look at financial distress, there is a European mentality towards financial distress, or is it, very much something that you still need to look at from a jurisdiction to jurisdiction basis? Because, yeah, I mean, we have seen efforts made to come to a harmonized substantial law on insolvency, but that's extremely different. And the best that we've, been able to do with the model law is procedural. Obviously, there are still ambitions within Europe to harmonize. But would you say that, insolvency is so close to public policy of a jurisdiction that it's very difficult to harmonize it? Or are we also on the way of actually, doing that within Europe? There is a European mentality towards financial distress.
I wouldn't go so far as to say that there is a European mentality towards financial distress at this time, but we're taking baby steps in that direction. And the first step was the introduction of the preventive restructuring frameworks throughout the European Union on the basis of the 2019 directive on restructuring and insolvency. That directive came from the idea that also in Europe we need a rescue culture. We need to look more at the rescue of viable businesses instead of, as was traditionally the case, look at insolvency through a liquidation lens. And the European Commission essentially said, listen, we have too many systems in Europe are aimed, in too many systems in Europe, insolvency leads to liquidation and the unnecessary loss of jobs, the unnecessary death of otherwise viable businesses. And we need to change that. So we are in the process of installing this rescue mentality, this rescue culture in Europe. But if you look at how that directive has been implemented in the various member states, you see a lot of varieties. So you still need to look at a jurisdiction by jurisdiction basis. And it's not just, you cannot change a mentality by simply changing the law. Everybody needs to be on board. Yeah. So practice needs to embrace it. The judges need to embrace it. The lenders need to embrace it, etc. That takes time.
And no, that's understood. But if you look at practice, you see, and maybe zooming out a little bit and look at the geopolitics of today, it looks like we're going a lot more, territorial these days, looking at your own sovereignty, and you see in our space also, competition between jurisdictions as to who has the best, framework for rescue. Do you think that inherently is an obstacle to actually moving forward with a harmonized insolvency law? Because there are sovereign interests at stake, and they don't want to lose position. So, a harmonized insolvency law is not what they're aiming for. Or am I too negative in that? And do you think actually I have seen, baby steps in the right direction, but it's still, a viable path to go?
I think it is a viable path to go, but you have to be very careful. So the European Union is still taking steps in this direction. And so later this year, so towards the end of 2025, we will see most likely a new directive harmonizing certain aspects of insolvency law. Now that's a very difficult thing, a very difficult issue to harmonize in Europe, because the position of secured creditors in insolvency is very different from one jurisdiction to the other. And again, it's not just about harmonizing the law, but it needs to work in practice as well. And I think what is an obstacle is that legislators, European legislator, doesn't look closely enough as to what actually works in a particular jurisdiction. It is perfectly fine to come up with harmonized rules, but they have to, they must work. They must be effective in a given jurisdiction. And that means that if, for example, you introduce a system where that has a lot of court involvement in restructuring or in the enforcement of security. So if you introduce as a harmonized rule a system where there's a lot of court involvement, you have to look very closely at member states where courts aren't as approachable as they are in the Netherlands or the UK or the US, where they are very slow, where there is not enough institutional capacity. And I think that's where the real challenges lie.
So it needs to be infrastructure, on top of the law.
Yeah.
Because if you too heavily rely on the court system, but the court system doesn't function, then whatever you put in place is not going to work.
And you have, yes, indeed. And you have to be very careful as a legislator to fix things that aren't broken. So, and I think that's right. That's where the negotiations in for example, the Council of Europe are built. So why would the Netherlands need to introduce rules based on, let's say, Southern European approaches towards the enforcement of security, where we have a system that essentially works quite well? Don't try to fix something that's not broken.
So do you think there is a demand from practice to to have a harmonized insolvency law?
I think it depends on who you ask. There's certainly demand from politics, and you see this with the Draghi and Letta reports, who that look at the competitiveness of Europe as an economic bloc, and they say, well, in order to facilitate cross-border investment, cross-border financing in Europe, which is key to generating economic growth, essentially they say, well, then you need to you need to take away the obstacles that are the result of these vastly differing insolvency regimes. That's one piece of the puzzle. Is there a big demand from practice? I think for lenders and investors, it may be a good thing. It'll reduce transaction costs if it doesn't matter whether you invest in the Netherlands or Poland or Greece. From a legal perspective, again, you still have to look at the law in practice. The law in the books doesn't say it all.
I mean, one of the things that I sort of have experienced myself in practice is that clients, distressed investors, lenders, people involved in the special sit space, if there is cross-border situations, they really want to have predictability, because predictability allows them to, calculate the risk, price the risk. And that is important, even if the result isn't great. If it's predictable, they can price it. But if it's uncertain, it's almost going to be priced too expensively anyway. And therefore, opportunities may fall away.
True, that but being, you can have predictability also in a non-harmonized scenario. And that is essentially what the European Insolvency Regulation did for the EU in the insolvency space, by creating more predictability, more certainty as to the jurisdiction where a company could actually go into insolvency. And a very important question, what law would apply to various issues that would arise if insolvency proceedings were indeed opened in a particular jurisdiction. It's not perfect, but it creates more predictability, more certainty in a scenario where the laws are different.
Yep.
And let's not fool ourselves. Harmonized laws, but they need to be it only leads to predictability, the necessary amount of predictability, if they are applied in a harmonized and uniform way.
That's exactly that was the sort of other piece I wanted to bring in is my experience with I guess implementation of the model law on cross-border insolvency. Chapter 15, you have the cross-border insolvency regulations 2016 in the UK, and you have other incorporations across the globe. The whole idea behind it was to provide predictability, because then if that is incorporated in the law, you have predictability on the procedural side. But actually practice shows that with the right intentions, because I think the intention is we need to have sufficient flexibility to have the right solutions for the specific cases. But if you create that flexibility, and therefore on a case-by-case basis things are different, it impacts the predictability, right? So what is better, to aim for the right result because you have in a specific case because you have flexibility, or do you want to have maybe a rougher rule that is predictable but may not be always the best in every situation, but since it gives predictability, it creates much more incentive for investors to price it and go into those jurisdictions. Very difficult balance, I think, but that's where we're going, right? Look at the differences in interpretation between the UK and the US, and for example Singapore. Those three are involved in one of the lectures I'm involved in the global insolvency practice course on cross-border insolvency regulation. The differences are sometimes quite stark, and it's supposed to be the same model law.
True, and that's why an instrument like the European Insolvency Regulation, I think, works in the European sphere, because it is the exact same law in all jurisdictions. It's a regulation. It doesn't need adoption, implementation into national law. But we also have a Court of Justice of the European Union the day tells all our national courts this is how you should interpret it. And the UNCITRAL Model Law doesn't have that luxury of having a supranational court to tell us this is the rule and this is how you should interpret and apply it.
Yeah, well, look at, they've tried to do it with an additional model law, the model law on enforcement and recognition of insolvency-related judgments, and nobody actually adopts it. So, that doesn't fix anything.
No, true. But when it comes to predictability, I totally see your point. And of course, investors, lenders, I think the market requires predictability, certainty as much as possible. But you also need a fair amount of flexibility. And that's what you saw happening, like something that we spoke about earlier, let's say about 20 years ago, when Europe discovered the UK scheme of arrangement as a restructuring tool. That worked because the UK system is very flexible and allowed all these European companies to use this tool to restructure in a way that they would not be able to in their home jurisdiction, and then take that result from the UK back into Germany, Spain, the Netherlands, and make it work. You need that kind of flexibility. And I think you will always see um, practice looking for the proper solution to a particular problem of a client.
Yeah. So we've sort of discussed a little bit the development of insolvency law, special situations as a space, as a dedicated, specialized area standing on its own 2 feet. I want to maybe go back to law school and you being a professor in insolvency law at the moment, and you looking back and looking forward as to what a Dutch law school is, if you compare it to the US and maybe the UK, and maybe look at that in the context of where we are today, especially if you listen to, the US. It seems like, the academic, as we know it, the academic track is broken or needs to be fixed, or, isn't up to date anymore with the reality and the practice. What are your thoughts on that, if you look at it from a Dutch perspective, which may be quite different from the UK and the US? What are your thoughts on that? What was it 30 years ago? What is it now? And if we're going forward, where does it need to go to?
I think it very much depends on the law school that you're at. The law schools that I've seen in the UK and the US, or in Europe generally, it matters what the focus of teaching and research is at that particular law school, and that differs. If I look at my own law school, as I said earlier, back when I started, and it's still the case today, we believe that it is very relevant to not just teach our students the law, but to show them how it works in practice as well. So our research and our teaching has a strong practical component to it. Whereas at the same time, it's still a very sound academic community and sound academic work of critical analysis, but through a practical lens. If I look at my law school, I think that works very well. And I think it works for our students as well. And I don't see a particular need to change that, unlike other law schools have done, where they've essentially rebuilt their curriculum to make it more interdisciplinary, so to introduce substantial chunks of psychology, social sciences, and the likes. It is relevant as an academic, also as a law student, to at least have a basic understanding of different areas of academia. But we still need to train lawyers. But I think, at the end of the day, a law school, any university, should be a place of critical reflection and debate and free thought. And it should be a place where you encourage critical reflection, critical debate in a safe space, of course.
Yeah. I mean, maybe just a couple of comments on it. One is obviously that if you compare the Netherlands with the US, the price of actually going to law school is completely different in the Netherlands than it is in the US. I think, artificial intelligence, AI, is massive for private practice as well. And one of the huge issues it sort of raises is how we're going to train our juniors when AI is there. And I think, it also brings to the fore, I guess, the issue of the model of a law firm, a typical law firm in private practice, is leverage, is having a large team looking at things, but involve junior people, and they can sort of learn on the job, and the client pays for that. Well, is that model going to be sustainable if AI is there? And I think if you talk like with in earlier conversations I had with people from the US, it was very much a point. Well, you have a system that is broken. If you come out of law school with 300 or 400,000 in debt, you do need to have a job that can actually sustain that. If that's no longer there, do we need to look back at what it is that law school actually does? For me to learn how to do research in the library is no longer relevant, right? Should we truncate the law school with maybe 1 year of studying the law, but then having 2 years of sort of practice, apprenticeship, maybe with with private practice? What are your thoughts on that? Because AI has a huge impact, but it seems to have the impact both in private practice and in academia. How do they work together to actually resolve this?
It does have a profound impact, and you will see a change in practice, and you will see a change in law schools. I think it's very important to just mention that, and at least this is true for the Netherlands, law school is not is not a place where we train attorneys for private practice. We train lawyers, whatever they're going to do when they grow up, in the academic approach to law, how you study it, how you critically reflect on it. So, and we have to keep that in mind, because our curriculum is not based on the fact that we train lawyers to then join a law firm necessarily. Having said that, of course, we need to keep in mind that many of our students will go into private practice and will join a law firm, or join a bank, an investment firm, or the government. And in whatever they're going to do after after their studies, they will be confronted with the use of AI, and it poses challenges. So again, a law school, a university, is a place of critical reflection, critical debate, and we tend to test the analytical skills of our students and the development thereof through essays, LLM theses, PhD theses. Well, AI allows you to write an essay in 20 seconds.
Yes.
If you have a proper platform that has access to the relevant sources, it may actually be a very good paper. Students that do not have access to proper platforms, I can still filter them out by looking at the footnotes at this time. You will see existing authors with existing law journals, with existing titles of articles, but not in that combination, because that's what, for example, GPT does, because it doesn't have access to information that's behind a paywall from the publishers. But that's going to change, and it is changing. And we need to think about, how do we continue to train our students in that critical reflection, and how do we test that, while at the same time using AI?
Because if it's a tool, you would expect that law school is going to teach you how to use that tool for the purposes that it may have, private practice, in a bank, whatever it is. But it is going to be, something that you need to be able to use. But it still needs to, turn you into a critically thinking practitioner, whatever that practitioner is going to be. And if I look at, you and I, we learn it by doing the reps, right? But okay, the reps are now different going forward for the new generation.
Yeah. No, so we need to train our students in the use of AI. Because it's out there, and they will have to work with it in private practice or whatever it is that they're going to do. But at the same time, you want, I think, and there will still be a need for lawyers that actually understand what the artificial intelligence platform that you use actually produces. That understand why it's relevant in this particular case. That understand how you should prompt your AI platform to come up with a proper answer to a question. But yes, work will change, and you don't need a large amount of juniors to do your due diligence anymore, because your artificial intelligence systems are way better equipped to do that quicker and more precise.
And what do you think, Michael? Do you think that, because one of the things, again, looking at the states for a moment, and again, whatever happens in the state doesn't necessarily one-on-one apply elsewhere in the world. Sometimes it doesn't apply at all. But there's, I guess, a movement there as well, looking at the universities there, the high costs, the sort of maybe restrictions there are to have this, free debate on, all the issues that there are, what a university should be. There are movements out there to see if you cannot replicate the substance of your degree in, much cheaper online courses. I think, we spoke about it. I think one person that is sort of prominent, and he is, in a way, he is a trailblazer in a number of things, is Jordan Peterson, right? With his Peterson Academy. He's obviously, a controversial person because he has clear views on things, and he's actually not afraid to bring things up and discuss them. But in the States, obviously that resonates a lot more. Do you think that something similar may happen in Europe and in the Netherlands? Or do you think actually, the universities are still so unique in what they provide that there is no competition from anybody that tries to do something online?
I hope we don't move in that direction. I don't think competition is bad. I think competition is good. It challenges you. You addressed, let's say, regulatory competition before. I think it's very good for legislators to look at, okay, what doesn't work in my law? Why do our companies move elsewhere? And then think about what they should change. So universities law schools need to look at what's happening out there. A university is much more than a place where you pick up knowledge. I fully agree that you can, by having the proper set of books and online courses, you can gain a lot of knowledge. But knowledge is not the same as understanding and critical reflection. And I think there will always be a place for universities. And again, at least from the Dutch perspective, our law school is not a place where we train people to go into private practice and to function in private practice. No, it's an academic institution where we educate them with both knowledge, but essentially understanding and critical reflection and critical debate. And if I look at, if at my own law school and I see the way in which students amongst each other interact, students interact with lecturers, researchers, but maybe it's age, Peter, I don't know, but I don't really see how you can replicate that online. Of course, the COVID pandemic required us to do our lecturing and teaching online. And what I really, really missed at that time was real interaction and real debate. I don't think online can replicate that. So, students may pick up their knowledge elsewhere, but that's not the same as getting an academic education.
Yeah. And you say there are two roles of a professor, right? Research and lecturing. And are they equally important? Because I think one of the things that maybe, is also a reason for doing something online or competing with, universities is that the lecturing may not be as compelling because it's a very good researcher, but he doesn't or she doesn't really lecture very well. How does that work? Is lecturing actually important? Because some people have a gift of actually, inspiring people in a lecture, and some people are great at research, but not really great at lecturing. How do you make sure that that balance is there?
So both are important, at least from my perspective. Research is also important for teaching because it allows you, it requires you to stay up to date. And teaching, a proper lecture requires you to tell your students what the state of the law is at that moment in time. So the two work together. When it comes to, let's say, career paths, yes, of course, some people are better in research than in lecturing. At our law school, and I think this is true for all law schools in the Netherlands, probably also Europe, or large parts thereof, everybody needs to do teaching. But of course, you try to, you should try to develop career paths that are geared towards someone's talents. But listen, this is from a theoretical perspective. I'm currently dean of my law school, and I'm faced with the necessity to execute severe budget cuts. I'm telling my staff that they should do more teaching because that allows us to, let's say, essentially cut the budget by letting people go without firing them. We just don't renew new contracts. We still have the influx of students, but we have to do the same teaching with less people. So in real life, it's all hands on deck when it comes to teaching. That's how it
is. So running, a law school is what you're sort of now be faced with, and then cost cutting, in any business is tough. I guess alongside it's also adjusting the working culture within the universities. Again, if we look at the States, there's some Well, there's some shocking things going on there where certain professors are, basically fired if they say certain things or if they support certain things. You were saying yourself that an essential feature of universities is that it is a safe place to actually express views, have a debate, and those views, even if they're not maybe the standard views, but they're a little bit outliers. The whole idea is that you will, in debate, test the views, but not like deplatform people or fire them if they express something like that. And you were saying, earlier on in the conversation that one of the things that attracts you to academics and law school is the societal engagement. Well, is there a limit to societal engagement if you're a law professor? Can you get into politics or should you stay out of that? I mean, it's a question that, law firms are addressing themselves. Do they need to be neutral and focus on the substance, or do they actually also need to express a view? And as we've said, at the very outset of the conversation, mentality in a country is very much, connected to politics, to, culture, to everything. So it's sort of, how do you stay in your lane if that is what is required?
I think academic institutions like universities are and should be and remain independent. What's happening in the US, where the government says, if you say this, we will, it'll impact on your funding. That is fundamentally wrong, very, very wrong. And so the position of many universities in this respect is that academic freedom and independence of researchers is key. But institutional ties between universities should be measured against, do our partners also embrace this academic freedom? And of course, very importantly, do these partners directly engage in or support through their research or their teaching the gross violation of human rights? I never thought I'd see the day where you could perhaps question partnerships with American academic institutions, where through the approach the US government is taking currently under Trump, academic freedom is actually at risk. And I think we should cherish that academic freedom. That is not to say that if you are an academic, you should not go into politics. But you should always be clear. I mean, I have a number of colleagues that I have one colleague who is a member of the European Parliament. I have colleagues that are active in the Dutch politics in whatever shape or form. There's nothing wrong with that. There's nothing wrong with being an a free academic, and being engaged in private practice, as I am, as long as you are clear and transparent about what you say in which capacity.
Yeah, I mean, maybe just to say again, people can have views as to what Trump is doing. He's obviously, also responding to what was there before, and he is a very vocal person. But again, the debate on what he does and whether it is good or bad, and whether there is merit in certain things he does, but maybe the way he does it, could be different. again, the debate is very difficult because you have a lot of people, especially in the US, who just immediately associate Trump with fascist, and therefore, end of the discussion. He's in that box. If you even, consider saying something that, is constructive or positive about him, well, you're a fascist too. It's like, well, that stops any, meaningful debate, doesn't it?
It does. And just going back to my law school as an academic institution, that should never happen. You should always be able and allowed to express your views in a respectable manner with respect for other people's views. So not be offensive, but you should always be able to have an open and free critical debate. A safe space is not the same as only hearing things or only being required to listen to things that you like or that you agree with. A safe space is a place where you can actually disagree, but in a respectful manner. And I think as academic institutions, we should strive to be that. And it's very difficult. I fully understand that in the US, it's under pressure.
I think something else that is quite toxic, but something that needs to be addressed, and also, I guess, in our space, special sits, is something that's relevant, is DEI, right? Diversity, equity, and inclusion. I think we've seen in the 30 years that I've been in practice, a lot of change, and hopefully more change is on its way. What are your sort of experiences on that topic, maybe within the university and just generally what you've seen in our area of specialization, which when we started was very much, one-dimensional, especially in the Netherlands, I think. But then, it has grown into a lot more diverse, more women, more people with different backgrounds involved, and obviously doing things cross-border. Inevitably, you're going to come across, people that are, different from your own country. So all of that, I think, is very positive. But at the moment, it seems to be that this is, again, something that is too hot to handle. What do you do about that?
Well, Peter, let's face it, we're both white middle-aged men.
Exactly. So 30 years ago, we were, in control. I don't think that is the case anymore, necessarily.
No, unfortunately, it is not. It is not the case anymore. When you and I started out in practice or in academia, in my case, it was very difficult to find anyone but white middle-aged men who were involved in insolvency, restructuring, and the like. That has dramatically changed. And I think that's a very good thing. Because like any societies, I think, thrive by having different approaches, different perspectives, and bringing them together. I don't think it really matters what you do, just to have different perspectives on the same issue is hugely beneficial, helpful. So yeah, it has changed. Now,
but it's also, Michael, a little bit of a zero-sum game, right? For many, it is like, okay, if you're gonna try to get a shortfall in something cured by preferring one over the other, then the one that is preferred, okay, but the one that isn't preferred will feel that there's sort of collateral damage for that policy. But how do you then sort of how do you close the gaps that are there if you don't do that? And it's a tricky balance, isn't it?
Yeah, it is, and it's very complicated if you let's say prefer, for example, men over women, because you have gender inequality, gender imbalance in your institution. We've seen that happen over the last couple of years, where law schools in the Netherlands actually agreed with the government that the majority of 50%, I think, of new appointments, professorial appointments at law schools should be women. That led to obviously more women being appointed as as professors, which is in itself a very good thing, because also in academic institutions, and I think the same is true for law firms, the partners, the people in the top, there is still a majority of men, and that majority does not reflect the current, in our case, influx of students. The majority are female, and I think the same is true for law firms. But what that led to was very difficult decisions on our side as a faculty board, for example, where we had to say to very talented young men, rising stars, we cannot promote you now. We can only promote you when we've reached these key performance indicators, which we've agreed on with the government. And I think that is very, very difficult.
Yeah, and that's maybe also the backlash to DEI has sort of gone the other way too much of it. It was the focus of everything, and then all of a sudden now there's a retreat. But again, it's an issue that we need to face, whether you like it or not. And it is something that's ongoing. And it's better to be able to talk about it than just, again, it being so toxic that if you mention it, you're this or you're that, and that's the end of the discussion.
Yeah, I mean, you have to be. This is something that we need to talk about, indeed, and we need to show one of the things that we try to do is to allow our students to to experience from, let's say, first-hand experience from successful people in the insolvency and restructuring arena. And if they're women, for example, and there are a lot of very talented, really strong women out there, this sends an example to the students. That's what I'm trying to say. This sends an example to the students. I can do that too.
Yeah,
I think that's very. Yeah. It doesn't solve the problem per se, but it's one of the things that you can do. And we have to, when we hire people, make sure that the committee is not comprised only of white middle-aged men, because they tend to hire white middle-aged men. They tend to hire copies of themselves. So if you have to, there's various things that you can do. But I'm not an expert on this in this field.
No, look, I think we've sort of addressed it. It is it is a work in progress. I wanted to go back to maybe something that we started with, and that is, I guess, financial distress, failure, challenges, struggle, overcoming, obstacles. It is something that in life, the older you get, the more appreciation you get, that actually you learn a lot more from, not achieving a goal than sometimes achieving a goal without any obstacles in your way. But with, I guess, the current generation, social media being what it is, if you're in your own little bubble with the algorithm feeding you, what it is that you're interested in, it looks like the whole world is doing great things, and you're sort of, on the pedestrian track, and not much is happening. What sort of, the experiences that you've had in your career overcoming obstacles and actually, succeeding in the end, but only because, the road was a little bit more rocky as opposed to, straight sailing, and, people looking at you now in the position that you are, they say, well, that's great, but okay, it wasn't always that easy to get where you are. What are your thoughts on that, for the next generation to come, and maybe some experiences that you've had yourself?
I think in general, you have to be patient, and you have to be willing to invest time and energy and effort into getting where you really want to be. And it doesn't happen overnight.
No
And that's
shortcuts.
what, yeah, there are no shortcuts. You need to invest in yourself, whether it's, as in the US, large sums of money to get a proper education, whether it is, doing work, being in a job that is not your dream job, but it's a stepping stone to something else. Acknowledging that it usually takes hard work and a lot of work to get to the top, or to get to where you want to be. It doesn't happen overnight. So, and that's what I tell my students. I mean, if you really want something, I think you can get there, but you have to invest, and you cannot expect to become, let's say, a partner with a major law firm or even any law firm overnight, and expect that you can get there without putting in the hours that that are necessary.
So what does it mean then, in your view, having the experience that you've had? You taught people, you've been in private practice, assisting clients. What are the characteristics of somebody who actually masters his or her trade in the special sits space? What is it that you need to have, and what is it that you need to avoid?
It's a difficult question, because there are a lot of different players in the special situations sphere, who each have a very important role to play. So there's a legal advisor, there's the financial advisor, investors.
There's an expert, maybe, like yourself.
There may be an expert involved, but there may be a restructuring, an independent court-appointed restructuring expert. I think what is really crucial is that these people that are all necessary to get the job done talk to each other and understand where the other people are coming from. And a lawyer doesn't have to be a financial specialist, and a financial specialist doesn't have to be a lawyer, but they at least need to be able to talk to each other and appreciate the perspective that each of them have on a particular case, in order to be able to reach a solution that is proper and that is in the interest of the client, the client situation.
And isn't that just the essence of this space in the law? You were saying it yourself. Special sits is almost like the gym of the law. It has various areas that all come together in the context of special situations. Financial distress is the overlay, but it can be property, corporate, litigation, finance, environmental, whatever it is. And you need to have an awareness of all of them. You don't necessarily need to be an expert on all of them, but you need to be able to use them in order to, work towards a solution that solves the problem of financial distress in this space. And it's also, multidisciplinary, because you need to be able to work with others outside of the legal profession to do so. So I guess, you need to be a little bit of a chameleon in that way, not too specialized, but almost specialized in a lot of, generalist things.
I think that's true. And for me, as a lawyer, that is exactly one of the things that attracted me so much back in the day in insolvency and restructuring. It's a very, very often procedural part of our statutes, etc. It's a very sort of narrow area of law, but it's not at the same time, because it involves contracts, property, secure transactions, torts, administrative law, because businesses very often need permits to actually run to operate. Labor law. I mean, it all comes together in insolvency or special situations, and that is what I find so enormously interesting. And then in practice, in order to make it work, to attain a solution that works for the client, you need to cooperate with a lot of different areas of expertise. And I think, that's just also the fun part of what of special situations.
Yeah. You need to have an open mind and actually, be able to come to a negotiated solution to the problem. And there are tools to sort of, put pressure, have leverage, but ultimately it is going to be, a compromise that you're aiming for.
Yeah. And of course, I mean, that you should be able to understand the perspective of the other players on the same case, and that you should be able to talk to them and understand them is not the same as, not taking on your role and being very, fierce and forceful if necessary. Of course, as you mentioned, there are tools that you should use that you would otherwise use in other cases as well. But I think especially in special situations, it's this wide variety of expertise that is required to solve a particular problem and rescue a business and to give it a sustainable future. That is so interesting and so relevant. All these various expertise come together.
So, a recent trend in, I guess, the last number of years, and maybe it's just, something that was always there, but it has acquired a new name, is liability management exercises, right? Which is using existing documentation to maybe find a way to restructure, either with or without consent. And it's something that in the States is very much, has resulted in a number of big cases. I know that you're involved in one case that is a European case that is litigating in the US. So obviously, you can't say much about it. But that is, do you think that there's more to come in that space in Europe? Just general trend, or is it actually it's always been there? It's just a fancy name for reviewing financial documents, finding the baskets, the headroom, and just work accordingly.
I find that difficult to answer again, because I'm not active in practice on a day-to-day basis. But I think from my perspective, what you say is right. It's just a new name for things that have already been out there, that have been used before. But it's a trend. So you see increased attention for LME in publications, not academic publications necessarily, but in more practically oriented publications. But it's a combination of things that we've been doing, for a long time.
And is it part of like the curriculum of law school that you pick up trends in practice and try to incorporate it in your in your topics in law school, or not really?
No, of course. I think when I teach insolvency, and for example, one of the issues in these liability management exercises is transactions avoidance.
Yeah.
So I don't have a module on liability management exercises in my courses on insolvency law, but I do have a module on transactions avoidance. And it helps to explain to our students, for them to understand the very often difficult rules around transactions avoidance if you give them practical examples. And so basically what I generally do is, look at the newspaper, see whether there's a case that provides an example of something that is relevant to the module I'm teaching there. And the same is true for, well, again, transactions avoidance. I may use an example of a liability management exercise with necessarily explaining in detail what that is. So they may very well they do. Our students are exposed to trends that emerge in practice. I want to show our students why it is relevant to understand and master the theory behind the topics that I teach them. It helps them to understand, why it is relevant, why we teach them, and how it works, and what they should do with that knowledge.
Maybe one part of, I guess, your practice in private practice is acting as an expert in litigation. Can you maybe say something about that? What it is that you provide and what sort of cases do you get involved in? And that is, is that a large part of the advisory role that you have, or a very small part of what you do?
So I act in a variety of capacities, usually for foreign courts where issues of Dutch law are relevant. And to give you a couple of examples, so a number of years ago, I acted as an expert and provided an expert opinion for the benefit of the English courts on the recognition in the Netherlands of scheme of arrangement. And this was one of the first cases where this was relevant. And of course, the English courts want to know whether what they do and say, and when they sanction a scheme, whether it's going to be effective in the Netherlands or not. And I've done several of these cases since. So that's something that I do. You mentioned the issue of the liability management exercise. I explain for the benefit of a foreign court what Dutch law is and how it should be applied to a particular set of facts in a case. I acted as an expert witness in the fight in New York over the recognition of the Brazilian or the Dutch proceedings in the Oi Telecom restructuring a number of years ago. So
that was a very interesting issue. Yeah.
It was a very interesting issue. It was a very interesting case to do from a legal perspective. It was the first time where I actually had to go through a deposition and a cross-examination in the US, and that was an
a
experience.
Pleasant experience.
Well, looking back on it, it was it's a steep learning curve.
Yeah, it's pretty aggressive, isn't it?
It's very different to how we do things in the Netherlands.
Yeah. So we've touched upon quite a bit, seeing how things have developed over the last 30 years, what they are today. If we maybe take a moment and look into the crystal ball and look, what the future will hold, who knows? But what do you think is going to sort of, happen in our space going forward? I think we've touched upon AI, and, that's going to have a massive influence. Are there other things that you think are, coming down the pike that will have, an impact on our space? And maybe also, what do you see for yourself in this space in the next, 10, 20 years? Some thoughts.
I think from my perspective as a Dutch academic and Dutch practitioner, the most direct and imminent changes that are going to occur come from Europe and the harmonization efforts by the European Union in the insolvency sphere. I mentioned the directive that I expect to be agreed upon towards the end of this year. That is another step in the harmonization of insolvency laws in the Netherlands, and it'll bring profound changes. So we just spoke about transactions avoidance in the context of liability management exercises. The rules that are envisaged by the directive are fundamentally different from the rules on transactions avoidance that we in the Netherlands currently have. That'll have a profound impact, not just for the people at our Ministry of Justice that need to implement this into Dutch law, but it will have a profound impact on lawyers, bankers, investors in the Dutch market, because it will fundamentally change one of the crucial areas that you always look at. If the company that I invest in goes insolvent and a liquidator is appointed, will he or she come after me? Is my transaction safe or not? That risk analysis will fundamentally change, and you will see a lot more coming out of Europe in that respect. It'll be so. This is already. I expect this directive to be adopted this year, and then we have generally a year or two to implement that into national law. That will have a profound effect on the European market, but it's not the final step. There is more to come because there is a lot of, as I said earlier, a lot of political push to harmonize these laws. So
what will be the effect in the Netherlands then? What will be the big change that will occur through this, harmonization?
I think at first uncertainty, because we're being confronted with a set of new rules where we are accustomed to working with a set of rules that have crystallized in more or less crystallized in case law, where we have guidance, and practice will be faced with new rules where there is no guidance. And
so the old case law is not going to be relevant anymore.
Old case law is not going to be relevant anymore. And and this is a particular challenge for the European Union. I mentioned earlier that one of the strong points of the European Union when it comes to cross-border insolvency, as opposed to the UNCITRAL Model Law on cross-border insolvency, is that we have a Court of Justice of the European Union that tells all our national courts in the EU how legislation that has a European origin should be interpreted. And ultimately, when it comes to these European texts, directives, regulations, it is the Court of Justice of the European Union that has the final word, not the Dutch Supreme Court or the Italian Corte di Cassazione. It's the Court of Justice of the European Union. And that's going to take a while before we have guidance on what these texts mean in a European context. It's going to take a while. So it'll have a profound impact, I think, on practice.
So it's kind of a contradiction, right? You harmonize something to get more predictability, but what you initially get is more uncertainty and therefore less predictability.
Yeah. Yeah. And
wow.
I mean, if you look at the way these rules on transactions avoidance are structured, the Germans and Austrians, for example, will have less of an issue because it's very much they're familiar with certain crucial aspects of the approach taken in this directive when it comes to transactions avoidance. But for the Dutch, the approach is fundamentally different, and it'll take some time for us to get used to what's actually happening. As an academic, this whole continued move towards more harmonization provides so many opportunities. It is so interesting because as an academic, I can think about what harmonized rules in a particular area of law could or should look like on a European level. And that requires me, and I've done a number of these projects together with Reinhard Borg from Hamburg, it requires you to put together a group of experts from all European member states and develop an idea and develop, let's say, common rules. And that goes back to where I started as a young academic. The fun challenges, but the fun of doing comparative research in this way with a group of experts that not only tell you what the law in the books is, what the statutes say, but also how it actually works in their jurisdiction in practice. And that exchange of ideas is extremely enriching. And of course, we try to bring together a fun group of people as well, usually. So
that's your driver. That is what actually motivates you doing what you're doing. This discussion and cross-border comparison on substantive laws that are of interest to you.
Absolutely, and it's intellectually challenging. It's enriching. You learn a lot, but above all, it's a lot of fun. And work should be fun, I think.
Yeah. It's one of those things that recently I online sort of followed the saying goodbye lecture of Reinhard Friesendorp, another professor in your field. I was struck by, I guess, the impact that you have as a professor on the next generation of practitioners coming in. Because, many people come through law school, they all find their way into practice, but you actually have given them some tools, some knowledge, some perspective on what to do. And that must be very, satisfying and a great part of, being a professor in a law school.
Absolutely. As I said earlier, it gives me so much energy and satisfaction to be able to contribute just a tiny little bit to someone's professional development. And if you can have that even small impact on someone's life, I think that's magic. And there is nothing, and again, that is one of the reasons why I eventually went back into academia. There is nothing for me more rewarding than helping these very talented and bright students develop, not by telling them what it is or what the law says, but helping them find their way themselves, helping them developing their own ideas and their own opinions by confronting them with different perspectives. And that is tremendously rewarding.
And our space, if you're interested in the law, has a lot to offer in that respect, because it is not, defined to one area. It's many areas into one context. So if you like the law, there's a lot to play with in this field of specialization.
Absolutely. So, for example, in one of my courses that I teach on insolvency, of course, restructuring is a very important topic. And we devote a good amount of time to these restructuring tools that we now have. But one of the things how we try to bring that to give our students an understanding of what it is that they're dealing with is by bringing in people and who actually do the restructuring on a day-to-day basis and having them do a case study, and not just a case study where an attorney, a restructuring expert, or whatever, stands in front of a class and tells them how a particular case went down. No, we give them, the students, a case, and under the guidance of this restructuring expert, they will negotiate in groups trying to rescue this company with the tools that we have in our toolbox in the Netherlands and that we've taught them over a number of weeks. So that they understand the financial dynamics between putting a restructuring plan together, the importance of acknowledging the position that the various players have. It matters whether you're a bank or a supplier or representing the employees, for example, and for them to get an understanding of how important it is that they can negotiate and that they need each other to eventually come to a deal. And that's super, because you confront them directly, with various areas that they need in order to reach a solution.
And it's interactive, and it's real life. So that makes. What's your prediction on the WOA, and maybe your assessment of how it has been applied and embraced in practice so far? What are the initial, I guess, experiences with it, and where do you think it's going to go?
I think the initial experiences have been good. It's been applied from the start. It was an instrument that Dutch practice really lacked. That's why we used scheme of arrangement most importantly. But the scheme of arrangement is very costly.
We now have the RP, right, which is has an extra tool in it that obviously the WOA has as well, where you can cross-class cram down, and we're obviously trying to get to grips as to how exactly you do that.
Yeah, I have not yet heard that the restructuring plan is more cost effective than the old scheme. But
no,
you
there's
know,
still a little bit of uncertainty in how it works, and things need to be tested, which is inevitable with new instruments, right?
yeah. But there, the UK has the advantage of the fact that the restructuring plan follows on an instrument that already existed, the scheme of arrangement. It just adds extra
Absolutely.
tools. For
Yeah.
us, the WOA was a new tool.
Yeah.
And one of the reasons why I think it has worked well in practice and will continue to work well in practice is that our judiciary, our courts, have managed to give parties in the market the benefit of reliable and predictable solutions. Of course, that takes a little while, but the courts have organized themselves in such a way that even when there's only a small number of cases, all the courts in the Netherlands are equipped and have experience to deal with these kinds of restructurings. And I think that's worked. I think that's worked quite well. Of course, now the idea that the Dutch scheme, the WOA, can be used for, let's say, small, medium-sized enterprises, we should, I think, consider tools that are more cost-effective for that type of the market. This is what you hear back. It's just too expensive for many smaller companies.
So has it changed the role of the court? Because obviously you were saying initially it's inspired by the UK scheme and by the US Chapter 11. US Chapter 11, very court-driven, huge role of the court involved. In the UK, with the scheme, court is involved, but, not anywhere near as much as in the US. And in the Netherlands, I mean, maybe, it was different with bankruptcies, because that's where you have the officer of the court, the IP, the curator, or the, bewindvoerder, who takes, responsibility and only, deals with the supervisory judge. Is this now, a new role for the Dutch bankruptcy judge in a process that going forward will be used much more?
Oh yes, definitely, because like the scheme of arrangement, the Dutch WOA has been developed in a way to minimize court involvement, to only require court involvement where it is necessary. Sanctioning a plan in order to make it binding on non-voting or dissenting creditors. That's ultimately where the court should be involved. So the court is not involved throughout the entire process.
No, but it takes because you don't have an IP involved, right?
No.
Unless you have an insolvency expert involved, or you have an observer involved. It's the debtor in possession that does it.
Yep.
But the role of the court is, I guess, in comparison to what it was in traditional insolvency, a little bit more prominent, because they're needed, and maybe also have a role to play to give guidance and to facilitate a deal. So it's a different role than it was before.
Oh, definitely. I wasn't trying to downplay the role of the courts in the in the WOA process. It's an entirely different role that they play than in bankruptcy. And the process has been set up to minimize court involvement. But you're absolutely right. Courts play a crucial role in the process, and through their and essentially in the Dutch WOA, it's also through the mechanism that we've introduced, where before you go to the sanctioning stage, you can go to the court, or the debtor can go to the court and ask, listen, my class composition is such, my voting mechanism is X, Y, Z. If we do it this way, will that be an obstacle to you court eventually sanctioning the scheme? So you can get clarity, deal certainty up front on certain elements, and that is what I meant earlier. The way in which the courts have approached their own the development of their own knowledge base and experience by creating a pool of judges that deal with these restructuring cases has worked quite well. And quite quickly, you've seen cases coming out, court decisions that give guidance, and now lead to a situation where participants in the process have more clarity, more certainty, more predictability.
Yeah,
because the courts.
And what's the experience with the insolvency expert and the observer? Is that what people expected, or are there, teething problems with that, or is that working well?
Difficult question. I think practice shows, and if you look at the published case law, practice shows that they are crucial in many cases. To the integrity of the process, to actually even getting the deal done at all. And this is specifically true for the restructuring expert, but also for the monitor that may be appointed. So I think if practice shows anything, it's their relevance for the process.
It's interesting. I think personally, we don't have it in the UK with an RP, but especially the monitor or the observer, I think could play a role into RPs as well. And I do think that you don't necessarily need to change the law to do it, but you can use, I think, existing, civil procedure rules to actually do it. But it's a work in progress. The RP is very much, after 5 years in practice, it's been tested and tested. There's now a consultation out to maybe the practice statement updated a little bit. And it's very much being debated and hopefully being improved going forward. But it's interesting to hear what the experiences are with the WOA, where you have certain aspects that we don't have in in the UK.
Yeah.
So that you think that has a good future, more to come on the WOA side.
Oh yeah, I definitely think so. And over the last couple of years, you've also seen the WOA being used in a cross-border setting, which in its initial phase was not the case. Initially, the comments when the WOA was being developed were like, people observed this tool as a tool for the big law firms in Amsterdam, that they would only use for their large international cases. Practice of the first year or two showed that it was actually the smaller Dutch cases that made where the Dutch WOA tool was used. And now you see, if you look at Vroon, McDermott, Diebold Nixdorf, you see a number of high-profile international cases where the Dutch WOA is being used and tested in other jurisdictions. And I think that will continue to develop, and that will continue to be of relevance to people like you and myself in the special situations sphere when it comes to something we spoke about earlier: cooperation, communication, understanding how a particular process works, what it can do, what it can't do, because in many of these cases, it's not just one plan, put a lot of plans together, in parallel proceedings. And in order to do that properly, you need to be able to at least have an open mind and an understanding of the foreign process that you're trying to accommodate, or the foreign process that you're trying to put elements of your own legal regime into, in order to make the whole restructuring work. And that is a phenomenally interesting and challenging exercise.
Yeah. So for you personally, your interim role as dean will end in November. And then, more of the same. You're going to continue to be, the law professor on the one hand and the advisor in private practice on the other hand for many more years to come? Or is there anything specific that you sort of have set yourself as a goal that you want to achieve going forward?
I'm very happy where I am right now, as I should say, as a law professor who has the privilege of being involved in teaching, educating young, talented, bright people, and research. And the impact that research can have. My current combination of being a law professor and at the same time being advisor to a firm like RESOR, which does cutting edge work in insolvency and restructuring in the Netherlands.
Excellent. So maybe let's try to land the plane here. You've been very generous with your time, and we've sort of, gone around the houses and touched upon quite a bit. Maybe my last question to you is, now that we've established that special sits is, I guess, a specialization on its own. If there are younger people listening and watching this and they think, actually, I'd like to maybe have a career there, maybe academic, maybe combined with private practice, what would be your advice to them?
Don't specialize too early. Get a broad perspective. Because special situations is an area, as we discussed, where a lot of things come together. A lot of areas of law come together, but a lot of different expertises come together. My advice would be, take the time to educate yourself as broadly as possible. So to my law students, I would say, listen, don't think in year 2 or 3 out of 4 that you should focus only on insolvency. No, do everything. Get a broad understanding of the various areas of law that are relevant, because you're going to need it. I think that would be my advice.
And I guess maybe alongside with that, the cross-border element and the comparison with other jurisdictions. So if you have an opportunity to, go abroad, take that opportunity, because that will, help you get the perspective that is so, so important for this specific space.
Absolutely. My wife and I say that to our kids as well. Listen, after finishing high school, spend some time abroad. During your studies, spend some time abroad. It broadens your horizon. It gives you a new perspective on things that we very often take for granted, because we're used to the way things are being done at home in the Netherlands. So take that opportunity. It is so interesting. And for me personally, this sort of coincidental career path that I had that started in the summer of 1994 has led me to various places in the world, has allowed me to speak to people from all over the globe and learn from them. And that has enriched my life as a person, but also as a lawyer. I couldn't have fathomed when I did my LLM thesis back in the summer of 1994 that this 1.5 sentence that, as I said, my professor of private international law said, you know, we have special rules for insolvency, but I'm not going to talk about that now. That would spark a career where I found essentially a niche at that time in the Netherlands, cross-border insolvency law, that has allowed me to do so many of the extremely interesting and fun stuff that I've been fortunate enough to do over the last 30 years or so. And I would say to my students, don't think that you can plan everything that's going to happen in your life. Allow the coincidence to happen. Take a chance. What I did, I wanted to go into private practice, but when the offer came, would you like to spend a couple of years at the university after you get your LLM degree? If I had not said yes, if I had not allowed this coincidence, if I had not taken this, chance to do something that I wasn't planning to do, I would not be sitting here right now speaking to you about special situations where we've gotten to know each other very well. My life would have looked completely different. And I would say to young people, take a chance and allow the coincidence to happen, because beautiful things may happen.
Thank you very much. I've been very grateful that, there were opportunities for us to do things together, both academically and in practice, and much more hopefully to come going forward. Thank you very much for the conversation today, Michael. Really appreciate it.
You're very welcome, Peter. It was a great pleasure. Pleasure was all mine. Thank you.
Excellent. Good stuff.